some interesting folks. And I've gotten to know the Robina Institute, Kelly's shop, through that work, and really come to appreciate Robina quite a bit as well. In fact, Kelly, I talk you guys up all the time when I give presentations. Next slide, please. So we're in the state to do this thing called justice reinvestment, which is the kind of a catchphrase. It's been around for 15 or so years. It is intended to be a data-driven approach to improve public safety. The original idea was to really look at corrections spending and look for ways for states to sometimes, not build that next prison, or bend the curve of prison growth downward, and then be able to have resources freed up from expensive correctional budgets in order to reinvest those resources, typically further upstream in the system into better treatment alternatives, better supervision, and so forth. That's kind of the classic model. It is a program that's supported by the Bureau of Justice Assistance, a little bit by Pew Charitable Trust, but mostly BJA funding. It's not, so it comes to Minnesota with no cost to Minnesota. Next slide, please. The idea is to have a bipartisan interbranch working group, and we're getting that rolling. We do data analysis, we do stakeholder engagement, we develop policy options, all of that in what we refer to as phase one, which is where we are. And then the idea is to move into typically legislative session. Sometimes court rulemaking is one of the levers of policy change. Rhode Island, where I worked, was a state where the Supreme Court actually stepped up and made some really profound changes to their court rules as a result of the analysis and the presentations that we did. But once that, assuming that rules change and laws change, that there's policy adjustments, we have another team of people that comes in and does what we call phase two, working with the implementation of policy, typically with the Department of Corrections. That's usually a focal point of policy changes, not always. And of course, it varies from state to state. And then we also implement kind of a monitoring process. That's okay. Go ahead, Nate. You're good. We've worked in a bunch of different states. We're currently in Vermont, Minnesota, Kansas, Wyoming, and Oregon. Oregon is pretty much wrapped up, but I've had a little bit of touch on Vermont and Kansas, and of course in Minnesota. I've also been in Rhode Island, Pennsylvania, Ohio, Michigan, Montana, and a couple other states doing Maine was another big state for me. But it's, again, this sort of same idea of going in, doing a really deep dive into the data that the state has about what's happening in the justice system, sharing presentations with stakeholders and with the leadership group that often is, for me, I think it's kind of cool because we're often showing people how the system is working in a way that they never have seen before. Because we have some really good folks, mostly down here in Austin, who do the data analysis and help us create interesting visuals that portray what's happening. And hopefully if we get a chance to talk in more depth in December, we'll have some examples of that kind of thing. Go ahead, Nate. So we've been kind of lurking around Minnesota for years, actually. I first came and visited your capital in 2015. And I think I met with Kelly when I was there. But the effort sort of ramped up in the last couple of years, and we were talking with your state leadership back in 2019 and talking with funders and trying to get it all to line up, and it took a while. But in 2019, this is a summary of the scope of work that was under discussion, that was really focusing in on the supervision component of your correction system, on the fact that there are these three different delivery systems, and sort of teasing that apart and understanding how well that's working for the state. It is a somewhat unique approach to a county-based supervision system. Number 4 on this list had to do with the way that the prison system budget is developed. And as it happened, that changed in this last session. So number 4 as a topic has kind of fallen away. There's no need for us to go there, but we are, I've actually mentioned this to Nate, we are wondering about the prospect of doing a more robust analysis of supervision populations, both as a matter of building the state budget each biennium, but also as a matter of analyzing legislation as it comes forward. So that in the same way that you look at the prison population and project impacts up or down and costs up or down, that we be more concerted about doing that with the supervision population. Next slide, please. So in July, I believe, House File 63 was enacted, which has your budget and the public safety and judiciary budgets. And embedded in the corrections part of that document is a charge to create a working group that is described here, or at least the mission for that working group is described on this slide, page 7. This is kind of a summary of what it says there. And there's 3 basic goals. We are supposed to come up with a new proposal for the way that supervision should be funded, a definition of what should be funded, what everybody in counties and in the state should feel responsible for accomplishing in supervision. And I think kind of a later add-on was the idea of at least coming up with a plan for how tribal governments could be more involved in the supervision system, possibly a way that tribes could receive state funding in order to run their own supervision agency, essentially. And so that's something that is kind of a new wrinkle for us that will be really interesting to flesh out. Go ahead, Nate. So I touched on these topics before, but this is also kind of a summary for me of who the people are on the project. My colleagues Jess and Matt, who you may meet at some point. I think Matt might be tuned into this event right now. They're doing the actual data analysis. They've got data from the Sentencing Commission, from the Department of Corrections, including both the prison system data as well as what's called the S3 supervision system data. And so overall, I would say Minnesota has terrific data, much more so than many states. And I attribute that to some extent to the fact of having a sentencing commission. I think it's a long-standing commission like yours. And in other states where I've worked, like Kansas, it really provides a leg up just in the quality and consistency of the data collection. So kudos to you all for having that. We talk to all the stakeholders we can lay our hands on or get on the phone with. And I wanted to say, any of you that would like to follow up with me and chat about this project, I would absolutely welcome that. I may reach out to people myself, but if anyone's really curious about this and wants to hear more, I'm totally available to do that. And my colleague Michelle, whose email is at the end of this presentation, is another contact, and I'll give you my contact information too. We have another colleague named David Demora who has had 80 Zoom visits with people who work in supervision or are on supervision across the state of Minnesota. So he's been doing a really deep dive into what supervision really looks like from the perspective of management, from the perspective of line officers, and the perspective of people who are on supervision. David is about as old as I am and has a really long, interesting history in our field as well, and is really well positioned to be doing that kind of an assessment. And the last bullet here is kind of what I do. I spend all my time looking at the law, looking at case law a little bit to understand how it works, asking Kelly questions from time to time, looking at judicial policy and looking at budgets and trying to understand the way the money flows to counties and from counties themselves. So the budget angle on this project is kind of a new one for us. So it's been an interesting engagement. Go ahead, Nate. I think this is the last substantive slide, just to give you an idea of the timeline. We had our first meeting of the working group that's mentioned in House File 63 back in September. We had another meeting in October. Our next meeting is scheduled for November 18th, and we'll have another meeting in December and then probably another one in January. And a wrinkle in this project is that there are really 2 working groups. We're focused right now on the House File 63 group because it is constituted, and we've been talking to that group, Commissioner Schnell and a bunch of the people from the different supervision systems. We've been in conversations with them for months and months. So that group is kind of an outgrowth of a conversation that has been ongoing. But we also, as a feature of justice reinvestment, I mentioned this idea of a bipartisan executive group. That's a funder requirement, essentially, that there be a group that includes legislative leadership, executive branch leadership, judicial branch leadership, et cetera. And so that group is, I think, imminent. It may even be announced already. I haven't heard that it has, but I think people know if they're going to be on that group, and it's going to be formed soon, and we're going to use that group to kind of finally vet the ideas that we go into more detail with the House File 63 working group, which is a broader range of it includes a lot of folks from the county level and from the different supervision agencies and so forth. And then the executive group has, again, legislative leadership and folks that we would look to try to enact if there's any legislation that comes out of this, the folks that we would hope would help us champion those ideas in the legislature next session. So the last slide, I think, is Michelle's email. And if you want to sign up to hear more from the Justice Center, there's a URL. My email is the same configuration. It's creynolds@csg.org. And Nate and Kelly both know how to get a hold of me in any case. So that's it for me. I'd be happy to answer any questions.
Thanks, Carl. I really appreciate it. Does any commission members have questions at this point? All right, I guess not. Well, thank you again. You know, as I mentioned, we have a packed agenda today. We have to make sure we get through some things. So I asked Carl just to give the sort of overview of what this was about. He mentioned that there was a working group that met recently, and they've already seen some initial findings. So Carl's going to come back in December and show those and go through those with us as well, just to kind of center us on the kinds of things that CSG has been pulling from the data. We just didn't have time for that today. So, you know, look forward to working with you some more on this, Carl, and hearing more about what you find. Thanks a lot for coming today.
I'm going to stay tuned in. If you would prefer, I can go out and come back in as a member of the public.
You know, I can just demote you, Carl.
So let's do that.
If you don't,
I like
demote
Carl. If you won't take offense,
that's right. Good. Thanks, y'all.
Okay.
Right.
Oh, I can't, Carl. There's something funny with the way you entered the meeting. I can't make you a presenter, and I can't demote you. So, I mean, you can either be quiet, or maybe I'll eventually figure out how.
I will.
Eventually.
Either way, it doesn't really. It's okay.
Oh, I can demote you. Bye, Carl.
All right, so we're going to move on now to the main event for today, which is we have an action item to talk about custody status proposals. So at our last meeting, we narrowed the field of custody status options down to 3. Today, our goal is to, you know, get to the end and figure out which of the options are we interested in taking forward to a public hearing in December. What I'd like to do, I think we had a really good discussion last week when we talked about it feels like it was only a week ago, last month, when we talked about, you know, each of the proposals on their own. What we didn't get to was a comparative analysis, sort of talking about the proposals against each other. But I think we had a great discussion last time. And so I'd like to keep us in that discussion mode first. I'd like us to spend some time. I'm willing to devote, you know, about the next hour to this, just comparing and contrasting the different proposals. And I'd ask that we not make motions at this time, that we spend some time talking about the sort of pros and cons, and folks can put their opinions out there about, you know, the merits of one or the other, which one's better than the other, and talk about them in a comparative fashion. So my goal would be to have that discussion first. Then we could take a short break, come back, and then whoever wants to make a motion to bring something forward can make that motion. So I'd ask for that. Before we get to that, I want to actually give Nate an opportunity. You've sent out a couple of different pieces of information that are designed to help us understand these proposals comparatively. And I'm wondering if there's any that you want to highlight for the commission or go over quickly before commission members speak.
Madam Chair, 5A is pretty similar to last time. It's essentially a summary of the three proposals. It's just shorter than last time because we only have three proposals. So we've renumbered them. There's the displaying the half points on the grid, which is familiar from last month. Repealing the custody status point policy without replacement. So essentially custody status would be eliminated from the sentencing guidelines. With sort of a footnote that there's still custody status sort of involved in determining whether somebody's eligible for presumptive consecutive sentencing. But that's not really what people think of when they think of custody status. So really, we're just getting rid of the custody status policy. And that's if, for example, if you commit an offense while you're in prison or on escape status from prison, it's a presumptive consecutive sentence. So that is sort of custody status. And then 3 is also repealing the custody status policy, but replacing it with a 1-cell aggravating factor. So that's 5A. 5B is the estimated impact of the November custody status proposals. And we were sort of apologizing for this document last month. It was in sort of a draft form that we presented to you. In fact, we've updated the document. The version of this document that's now on the website has a bunch of lines through it because we've updated and corrected some things. So I apologize for the fact that we had to get that out to you in unfinished form, but this should be a finished document that talks about the impact of the various proposals. I'm not going to go through this, Madam Chair. If you're okay, we could just talk about it when we go through 5C. 5C is a comparison document. This is really a new document. Do you want me to display this, Madam Chair? Is that
Sure.
what's your will at this time? Okay. So try to get that screen here. So
I'm sorry, can I interrupt just a second, Madam Chair? When Nate, thank you. When Nate refers to the exhibit numbers or the attachment numbers, if you could tell us what the title of the document is. I printed them out and there's no reference to what they are.
So 5A, you're right, we don't put the numbers on the documents. So 5A is a summary of November custody status proposals. 5B also a staff information paper, estimated impact of November custody status proposals. And then 5C is the comparison of the November custody status proposals. And I should say, Madam Chair, members of the commission, I worked on this document with a great deal of fear and trembling. I don't usually stick my opinions in your conversations. And this did require some evaluative comments on my part. I don't think my role is to make decisions. I think my role is to assist you in making decisions. So I just don't want you to think I'm getting too big for my britches here and making these comments. I tried to call things as I saw them. I fully recognize that reasonable minds may disagree, and you're welcome to have a different opinion. But I just thought it would at least help get the discussion going if I gave you what I thought were some honest points of comparison about how these compared to each other. Now the comparison points are almost entirely taken from an evaluation staff paper that we did present in October. These are either taken, I think almost exclusively, they're either taken from the sentencing guidelines themselves in the statement of purpose and principles at the beginning of the guidelines, or they're taken from our charter statute, where the legislature tells us how to create guidelines, or in some cases they've been taken from recent commission discussions. For example, simplicity, there's nothing in the guidelines or the statute that talks about simplicity, but that does seem to be something that comes up frequently as something that people want to see in the sentencing guidelines. So the first point of comparison is public safety, and that's not hard to find in the statute or in the guidelines. We assumed that public safety outcomes for the half points would be more similar to the status quo than the alternatives, because the half points solution is really the most like the status quo of the three solutions. The for 2 and 3, we kind of lump them together because essentially their sentences of people who have a custody status are reduced, including some dispositions, which means some people who are now presumed to go to prison will no longer be presumed to go to prison under policies 2 or 3. But then we talk about recent research, and we include this very long article, a meta-analysis by Petrick and others, that indicates that harsher sentences are not effective at deterring crime. So that's a really interesting article. I mean, it kind of has broader implications than just this policy here, and you know, something that could be unpacked at great length, I think. And also there was a particular, for those who were on the commission back in 2018 when the commission was looking at this, they'll recall that Julia Laskaransky, who I believe was a research fellow for the Robina Institute, and I'm sure you'll correct me if I'm wrong, but she, Dr. Laskaransky did an analysis particularly of the various components of the criminal history score, Minnesota sentencing guidelines criminal history score, and found with respect to custody status that although custody status is predictive of recidivism, somewhat predictive of recidivism, retaining it in the scores formulation only helps identify an additional 1 out of 100 recidivists. And I think that's because there are other components in the criminal history score that do a better job of predicting recidivism. And there are links to both of those documents. In there, we've seen the Laskaransky document before. The Petrick document is new. I think it just came out this summer, and there's a link to that as well. Plus, it's in your meeting materials. The second point of comparison that we looked at was maintaining neutrality, reducing disparity. We observed with respect to option 1 that prison beds are reduced across all demographic categories. The white category, which now experiences one of the smallest imprisonment rates, benefits the most. The black category, which now experiences one of the largest imprisonment rates, sees the smallest percentage reduction. And you can see that in the staff impact statement. And I'd be happy to talk about that at greater length if you like. With respect to option 2, prison beds are reduced across all demographic categories. So that's the same across all 3 options. The American Indian category, which now experiences the largest imprisonment rate, sees the largest percentage reduction. So we despite the fact that there's a pretty small American Indian population in the state of Minnesota, they've been very much, well, I think you could use the term overrepresented. And I don't mean overrepresented in the fact that there's just on a numerical level, there are more people in that category in the various stages of the criminal justice process than you'd expect to see based on the population that they make up in the state. So they now have the largest imprisonment rate, although it's not too far off from the black rate. But the black and Asian categories see a smaller percentage reduction, but both are larger in terms of percentage reduction than you see in proposal 1. With respect to proposal 3, we don't really know with any specificity, and that's because there's so much unknown with respect to this departure factor. We just don't know how that departure factor is going to be implemented. But we do expect that proposal 3's impact in terms of distribution across different racial groups will be similar to proposal 2. But when it comes to neutrality and disparity, there is increased discretion in proposal 3. And potentially that increases the risk of non-neutral sentences. Now, we don't have any data to back that up. We don't know that it's going to increase non-neutral sentences, but it does have a risk of doing that because of the discretion that's involved. Comparison point number 3 is simplicity. So proposal 1 is difficult to assess. On one hand, it doesn't make any changes to the policy language of the sentencing guidelines. I hesitate to use the word policy because there was a case, State versus Kirby, that used the word policy and said that policy only referred to sections 1 through 3 of the sentencing guidelines, which I take offense at. I mean, well, I object to that because I think really policy is definitely found in sections 4 and 5 of the sentencing guidelines, particularly. But anyway, but I am sort of using this term in the way that the Supreme Court did. There's no change to the first 3 sections of the guidelines. The language is essentially almost identical. So there's less of a learning curve for practitioners. But I think there is an argument to be made that it does complicate things in 2 senses. One is the grids are visually more complicated. There's just more numbers on the grids. They're not quite doubled in terms of the number of numbers that are on the sentencing grids. And because there's so much more information on the grids, the example offenses, which we find are useful in training people, like what are the sentencing guidelines, generally when you're talking to, say, when I was a prosecutor and I'd be explaining to a crime victim what to expect in this case, I'd show them the sentencing guidelines. And the fact that there are example offenses on the left side helps clarify what's going on. I see. So this is a severity level 5 offense or a 4 offense. It's like these other offenses, and it's less serious than these other offenses and more serious than these other offenses. So it does help, I think, just general lay persons understand how the guidelines work. So that's somewhat of a loss. And then you also have the implication that there's now going to be a different rounding rule for each of the 4 criminal history factors. So we've got the prior felonies rounding rule, which is that you round down the half points. The custody status rounding rule, which is you don't round, you use the half point grid columns. You got the prior misdemeanors rule, which is 4 units equals 1 point. So you only find those units in the misdemeanors. And then for prior juvenile adjudications, 1 juvenile adjudication by itself doesn't count, but 2 are worth 1 point. So it's sort of similar to the misdemeanors rule, but it doesn't use the half points. So it doesn't use the units as a measure. So that arguably makes things complicated. But I guess you could also argue that that's not really the fault of this policy. That was a pre-existing condition, if you will, that was caused by my failure to merge the 2 rounding rules that apply to the half custody status point and the half felony point. Simplicity with respect to policy 2, it does simplify a criminal history score calculation, and it does shorten the guidelines because essentially we're eradicating section 2B2 of the guidelines, which covers custody status points. And you could also argue that it purifies the criminal history score in the sense that custody status, one could argue, isn't really criminal history. Everything else is what's in your past. Custody status is what was your status with respect to the government on the day you committed this crime, which arguably isn't really criminal history. Whereas you know the rest have to do with your record, either your criminal record or your juvenile record. Simplicity on 3 is it sort of has the benefits of 2 in terms of simplicity, except it does add a new aggravating factor. So that makes things more complicated. And it's also, I mean, certainly we have aggravating factors now, but this is a different kind of aggravating factor because it's limited in the scope of its application, or at least it purports to be limited in the scope of its application. Essentially, it's 1 cell to the right in most cases. So that's a new concept that's going to require training, and it's going to invite error. And this is the only proposal that we assume is going to increase the need for jury trials, because generally jury trials are required for the finding of aggravating factors. The next point of comparison is the idea that the sentencing guidelines should be rational, consistent, uniform, and proportional. So proposal 1 is the only proposal that applies an increased sanction in a consistent way to those who commit new offenses while they are under some form of official supervision. It also maintains the 2019 policy of weighting custody status in proportion to the custody offense's seriousness, which we could argue was a move forward in making the guidelines more rational, making them more fair, if you will. The custody status is weighted, and in fact, I think that's something that Professor Fraze brought up. That it's in his article, he was criticizing the pre-2019 guidelines for weighting custody status as a whole point, even if the custody offense was not a very serious offense. It also clarifies the sentence, which is certainly something we don't have right now. On the other hand, the method of application is not consistent with that of the other criminal history factors. As I said in the previous row, we now have 4 different rules for the 4 different factors. With respect to the proposal 2, this is the most rational and proportional proposal if, and only if, custody status does not actually increase blameworthiness. So depending on how you feel about whether or not somebody was being watched, officially supervised in some form, whether they were in physical custody or whether they were on probation, parole, or supervised release, if that makes the offender more blameworthy, then this is less rational. But if that doesn't increase blameworthiness, as Professor Fraze argued, then just eliminating it is the most rational proposal. It is uniform in its application, and there is, as I said in the outset, there is still a little bit of custody status that lingers on. If somebody is a prisoner or an escapee who commits a new offense, there still is that presumptive consecutive sentencing. And by the way, when you go with a presumptive consecutive sentencing, you have a criminal history score of 1, which I've always thought of as sort of being a proxy for the custody status point, because permissive consecutive sentencing, you have a criminal history score of 0. So there's still a potential sanction that remains for custody status even after repeal. With respect to proposal 3, it does invite a rational investigation into the circumstances of the case in deciding whether custody status should increase blameworthiness. On the other hand, because the decision to depart is discretionary, this is the least uniform proposal. After all, isn't this what the guidelines are trying to avoid? Is having they're trying to make a uniform standard that applies in criminal cases whenever possible. And this applies in a whole lot of cases, since custody status applies to quite a few cases. We've seen that before. So essentially, there's no real guidance in the guidelines on how to whether to apply this departure or not under proposal 3. And then parsimony, conserving limited state resources. By eliminating the need for an estimated 44 prison beds, it conserves the fewest, and that's, again, this is compared to the EWS method of calculating criminal history scores, which we know is really not the right answer, but we don't really know what the right answer is. So all these are compared to that that baseline. We talked about that in October. But by eliminating the need for an estimated 44 prison beds, it conserves the fewest prison resources of the 3 proposals. The second, by eliminating the need for an estimated 536 prison beds, it conserves the most prison resources of the 3 proposals. And we don't know about number 3, but we know it comes somewhere in between 1 and 2. We're not sure how many, because we don't know how often that aggravated departure is going to be used. Now, I didn't put this in here, but the flip side of this is, and maybe it goes to the public safety. I guess we did mention this in the public safety, but it is sort of does the public have an appetite for eliminating the need for 536 prison beds at this time? And then we just have the bibliography. So that's the end of the 5C. 5D is the text. And then 5E is this just a few slides here, Madam Chair, on where people with custody status points appear on the sentencing grids. So this is actually, we stole this graphic from Carl's presentation, the longer form presentation that we asked him to maybe defer for another month. But this is a heat map essentially of where people are showing up on the sentencing grids with custody status points. And you can see that it's not a lot in criminal history score of 0, which makes sense because they should have a custody status score and probably a criminal history if they have a custody status point. Most of these are in severity level of 4. Criminal history 2 seems to be the most common, although criminal history 6 also has quite a few. On the sex offense grid, we see that there is some application of the custody status point above severity level H, but essentially the vast majority of people with custody status are severity level H, which is the offense of failure to register as a predatory offender. And then drug offenses, we see that the majority are severity level 2, which I assume is for 5th degree. So that's really all I had to share, Madam Chair.
All right, thank you very much. Okay, so I think that Nate has set the stage for some comparative ideas between the 3 proposals, and I would really now open the floor to others to bring up any points of discussion that they think are relevant. And I'm hoping that we can hear from everyone during this period of time, but I'll take comments from anyone. Commissioner Moore.
Thank you, Madam Chair. Madam Chair, was Nate going to go through the estimated impact of these proposals at all? I had a question regarding some of the numbers there, and I didn't want to sound completely uninformed. I wasn't sure if he was going to talk about those items because I think those do have an important part of our discussion here.
I think it might be, I mean, certainly he can do that, but maybe go ahead and ask the questions so that he can make sure to address those directly.
All right, I will. And if I sound uninformed, you can tell me that. Nate, the question I had, or maybe for everybody, was the estimated resulting prison population, and in particular the percent point change relative to other categories box of the grid. And I was looking at the table 5, the estimated change in prison beds needed, assuming repeal of the custody status point. And so I noticed in the column there, we have a little disparity of the percentage point change relative to other categories. And I guess the question I had was, I wanted to make sure I had a good understanding of, for instance, with African-American prisoners, the percent point change relative to other categories was listed as 0.07%, and with white, negative 0.5%. American Indian, negative 0.2%. And so I guess my question was, putting that in other terms, does that mean that the estimated resulting prison population resulting from repealing custody status point, does that mean that the percent of the prison population that is African American will increase by 0.7% as a result of that?
Right, Nate, go ahead.
Thank you, Madam Chair. Thanks for that question, Justice Moore. I really appreciate it. So, because this is not self-explanatory at all. I mean, we're trying to make it as clear as we can, but I recognize that's extremely challenging. So we're looking here on the screen at table 5, which you're referring to, and there's a 0.7%. So what's going on here is we're taking, essentially it's this number here, this 36.79%. And we're subtracting it from this number here. I guess it's the other way around. We're taking 37.49%, which is what we're expecting to be the resulting share of the prison population that will be in the black category, right? And comparing it to the percent of the prison population that's currently in that category. And so you'll see, right, that the numbers are going down. So we're starting at a population of 3,534 and going down to 3,401. So that's a reduction of 133 and a half prison beds. So that group benefits, right? But it doesn't benefit as much as the other categories are benefiting. So in this case, you see so for that reason, the percentage of prisoners who are black is going to go up, even though so they're going to have a larger slice of a smaller pie, if that makes sense. So even though the number of prisoners will go down, the relative percentages will go up for that population group. Does that make sense, Justice Moore?
I think so. And so if you go to table 3, then just by comparison, this would be the estimated change in beds with the half-point proposal. So there it looks like we have less of a, I guess, an overall relative effect there. We've got a slightly higher increase percentage of black inmates and a slightly lower percentage of white, and apparently no real difference in American Indian, Hispanic, or Asian, if I'm seeing that correctly.
Yeah, no less. If it's blank, it's less than 0.1%. So we just left it alone. So yeah, that's true. So I mean, I guess the way I've always thought of this is it's really, what are you most concerned about? Are you most concerned about a particular group's share relative to the other groups? Or are you most concerned about reducing a particular group's population? I mean, so let's go back to table 5. So even with the for the black group, right? Their imprisonment rate would go down from 1,267 per 100,000. So that's like 1.2% or 1.3% almost of black adults in Minnesota was in prison on July 1st of 2019. So that's a pretty high rate. That's much higher than all the other groups except for the American Indian group, which was also at about that same rate. So if that's your main concern and you want to see that go down, well, it will go down. So that's what's shown here in the right column, that 3.8% number. I don't know if you can see my highlighting or my cursor at all.
Yes.
But okay, that's good. So it goes down here to 3.8 percentage points. So if that's what you're looking for, and it goes down even more for the American Indian group, which again, as I said, is even farther, is even higher. So, but it doesn't go down as much for the black group as the other groups. So that's why the relative share of the prison population is still going to go up. So it's not it's not necessarily an easy type of decision from a policy point of view to know, well, does this benefit this group or does it not benefit the group? Well, it kind of depends on how you're looking at it. I'm this is something we struggled with when we were first trying to come up with a demographic impact statement policy, because this is essentially modeled after the information we give in our demographic impact statements. And when we came upon something like this, we weren't really sure whether to say this is a good thing or a bad thing for the population that's identified as Black. So we just thought, well, we're just going to put out the data and let the policymakers decide what they value, what they think is important, what they think is good, what they think is bad. We're just presenting the data.
Thanks, Nate. Other comments, Commissioner Larkin?
It always takes me a minute to find the mute button. And I'm not sure how you want people to weigh in on these options, so I'll just kind of give a quick overview. What concerns me most as we have this discussion is public safety, because that is our mission. The legislature has told us our first priority has to be public safety. The guidelines say that the purposes of the guidelines includes establishing rational and consistent sentencing standards that promote public safety, reduce sentencing disparity, ensure sanctions imposed for felony convictions are proportional to the severity of conviction of offense and the offender's criminal history. And also says that we have to consider the long-term negative impact of crime on the community when we're assessing public safety. And because that's our primary focus and must be our primary focus, I have that in mind when I look at these three options, and then have to ask, how does repealing the custody status policy without replacement serve or enhance public safety? If we do that, we're going to be lowering sentences, whether it be putting people on probation who would have otherwise gone to prison or giving them less of a prison sentence as a result of eliminating that custody status point. And I appreciate the studies that say, well, longer prison sentences don't reduce crime. But no one's given me a study that says, but shorter prison sentences do. And I'm just, a reasonable person has to say, well, if someone's in prison, they can't offend against someone in the community. So there is some public safety component to having an offender incarcerated. So if we're going to reduce that incarceration, how are we going to offset the risk to public safety? And that's, I'm not hearing that. That's why I can't support the idea of repealing the custody status policy without replacement, because all we're doing is reducing sentences in a large number of cases without identifying what's going to happen to provide for public safety as a result of those reductions. Can anyone address that for me? That's what I'm looking to hear.
Commissioner Estrada?
Bear with me, my mouse is running out of battery, so it's taking me a little while to unmute myself. A couple of things, I think, based on the slides that were shown, when we looked at the percentage of predictors of recidivism, right, and we talk about public safety recidivism, it was 1 in 100 the custody status determined, if you will, or influenced. There are studies. Ted Latessa, he talks about dosage probation. He talks about 200 hours of programming for moderate risk offenders, 300 hours of programming for high risk offenders, increase or decreases recidivism by 1.7%, and every 20 hours, additional hours also reduces recidivism for that. There are those studies out there. Latessa, like I said, I'm happy to forward that to you. But I think that they're, you know, in probation, that's something that we're looking at as well. We have our risk and assessment tools. We're taking out questions in our risk and assessment tools that determine somebody as high risk, medium risk, low risk, that don't predict recidivism. They don't have an impact on recidivism, and what it does impact is essentially creating disparities for people of color. And we're removing those questions for our assessment tools with the same idea of public safety. I think we're all concerned about public safety here. I don't think anybody on this call is not concerned with that. I also think that it's important to recognize that a custody status point may not be the way to do that, especially as we look at the slides. And the other slides that really stood out were the distribution of the heat graphs that we just saw, and how many of these offenses are drug offenses with a criminal history of 2, or still are on the presumptive probation area.
Okay, I saw Commissioner Hansi and then Commissioner Larkin.
Thank
And
you.
then-
I just
Go
want to address Commissioner Larkin's question. I think that we need to end this us versus them when it comes to public safety. Public safety needs to include everyone, right? And that includes people that are that we're talking about in this instance, right? So their safety needs to be taken into account as well. And so when we're talking about this, why are we making it that, well, just to err on the side of on one side, we're going to continue to keep these people, make longer sentences where there's more retribution, there's more punishment, right? There's no shown cases of more rehabilitation from longer sentences. It's actually keeping them from families, communities longer. And so how does that make them safe? How does that make our community safer when we are keeping people from their community longer, and which in turn adds so much more trauma to their lives, and which in turn can turn to more just separation from their community, which can turn to more crime later. Thank you.
So Commissioner Larkin and then Commissioner Middlebrook.
I'm still struggling
Oh,
to
I think you're muted.
understand, because, okay, the notion of we're doing now evidence-based practices. And I think in Hennepin County's been doing evidence-based practices for like 10 years, right? I mean, that was sort of coming into vogue when I was there as a public defender. And yet we're not seeing crime rates go down, and we're not seeing people be more successful on probation. So I would love it if there were services that we could look to and say, yes, this is what we need to do. This will keep people on the straight and narrow, and this will keep people out of prison. But I'm not, just to vaguely say, well, you need 200, 300 hours of supervision. I mean, I'm willing to bet most of the people that go to prison have had that much supervision, because you usually don't end up in prison unless you've failed on probation 1 or more times. So I'm just trying to really drill into this notion that if we reduce prison sentences for all these folks, there's going to be a better outcome in terms of community safety.
Commissioner Middlebrook.
Thank you, Madam Chair. Just to address Commissioner Larkin's concern on what we do about public safety. I agree with what's been said by Commissioner Hansi and Commissioner Estrada. I would just add in a couple of things with regard to if you look particularly at 5E on the grid that shows who it is that's getting the custody status point. It looks from those 3 different grids, they all are, if you take out the failure to register under level H on the sex offender grid, all of those are really focused on, there's a lot of probationary sentences in those ranges where those are the heaviest. But, you know, as far as for public safety and the concern with that sentences are being reduced, they don't necessarily have to be reduced because there's other options that can take into account that the person was on custody status if they commit a new crime. And Director Wrights pointed out that particularly for the custody status with escape or while they're incarcerated, that they would be able to get consecutive sentences. That's one option. The other option is there's, you know, our grid ranges in each cell have increased dramatically over the years. Since Blakely came in, those grids, they went up, especially for the more serious offenses. Those ranges are really, really broad. And there, you know, the option would be for the sentencing court to give a sentence that's closer at the top or closer to the top of that range if someone is on custody status when they commit a new crime. The other option, it is, I mean, there's so many cases where the defendant will ask for a mitigated departure, and that can also be taken into account by the sentencing court on whether or not they were in custody status. So those are some of the options that would actually, I think, you know, help with public safety, those public safety concerns, because they're there where they can take that into account, where it's applicable and where it means something on that individual case. Just the idea that categorically we're going to apply this additional higher sentence because of custody status, it's just, it doesn't make sense with, especially where you look at who the people are that are getting these custody status points. And I mean, strikingly on the drug grid, it's the 5th degree controlled substance that's the, you know, and as we all know, so many of them, it's an addiction. It's not, that they need to get treatment. They need to get the community services for those, you know. And the other thing is, we talked about a lot last week with trying to move some of the resources into the community to have community-based programs that will help these individuals. So I do think that public safety concern is taken care of, even if the custody status is eliminated.
I'd like to also make a comment here, and then I'll let you make a comment, Commissioner Larkin. But I think the question needs to run in both directions. You know, how is public safety served by the custody status calculation that we have today, as well as how would it be served or not served, or is it not served if we remove it? And what I think about custody status, you know, it's not a traditional component of criminal history. It's, you know, all of the other components of our criminal history score, even as Nate pointed out in his document, measure prior offending. They're direct measures of prior offending, prior felonies, misdemeanors, juvenile offenses. But custody status doesn't fit that mold. So it doesn't fit the criminal history calculation for me. And so I have to think about, so what is it? And I think it's retributive. You know, it's really based on the idea that a person is more blameworthy because they have committed this new crime before they've served out the old sentence, and they deserve more punishment because of that. So I think that if you're asking whether taking custody status away somehow injures public safety, what you're saying is giving more punishment serves public safety. And I don't agree with that. I don't agree with that idea, because punishment doesn't always equate to public safety. There's many ways to achieve public safety, one of which might be incapacitation, but others of which might also be increasing services. And then I just also think that it's not necessary to serve public safety, because there are so many other consequences that can come to bear once a person has committed a crime while they're under one of these statuses. All of these statuses carry other consequences. So if you're on probation or if you're on supervised release, you're going to have a violation. There's going to be a violation hearing. There's going to be consequences that flow from that hearing. If you're in prison when you commit your crime, you're going to get disciplinary time, and your release date is going to be moved back. You're not getting out at the 2/3 mark at that point. So there's another consequence. So there's other ways, other things that come into play that already increase the punishment. And then the guidelines also already increase the punishment. If you commit a new offense after having committed offenses before, your criminal history is going to go up. You're already moving down the grid. If you don't move far enough, as Commissioner Middlebrook said, the court has the ability to work within the range and go up to that 20% above the presumptive sentence without any departure reason for that. So I think that we have a lot of ways that we can increase the punishment if we think it's deserved because of the fact the new crime was committed before the old sentence was served. But I don't think that equates to more public safety. And so for that reason, I'm not sure that custody status is a necessary part of the criminal history score or of the guidelines. And I think Commissioner Larkin, you had your hand up next.
Thank you, Madam Chair. I'm influenced by the fact that custody status is a traditional component of criminal history score. We've always considered custody status at common law. It's always been a part of the guidelines. I don't know that it's irrational to say your criminal history includes not only the specific crimes you've committed, but the circumstances under which you've committed them, that being you committed a crime while you were on probation. I don't think it's wrong to say that influences an assessment of one's criminal history. That seems like an important factor in one's criminal history. So to me, it seems very short-sighted to simply say, well, we have a problem with this half-point solution that was adopted in 2019, so we're going to, in a couple of meetings with the victim representative seat vacant, eliminate custody status from criminal history scores. That is such a major change, and it's inconsistent with what Minnesota's always done. And I appreciate people coming back to this, well, longer prison time doesn't equate with public safety. We need to put more resources in the community. But I'm not confident that's going to happen. And so I am concerned that reducing sentences across the board is going to compromise public safety.
Commissioner Moore, and then Commissioner Knudsen.
Thank you, Madam Chair. Madam Chair, and maybe Director Wrights, I'm wondering, has there been any analysis or study of the number of waivers of the custody status point that the district courts have given out? I mean, that's a relatively new change in the guidelines, and I was rereading that provision from the guidelines, and the waiver is all focused on public safety. I mean, the grounds for it is really premised on the offender establishing that the waiver is consistent with public safety, and there's a whole list of considerations regarding rehabilitation. And I wonder if that would give us some indication if that's working or not, because I think the heat diagrams are really revealing that the offenders that they're getting this custody status point in their sentences are really on lower severity crimes, and obviously the custody status point can't be waived on severity level 8, 9, or 10, or 11, the more serious stuff. So that's not even in the picture here. But I just think it might be helpful for us to know, is that a tool that's being used, and if not, why not? And I don't know if our county attorney or public defender representatives or people who have got connections to those organizations could help give us some data on that, because I wonder if we should see how this works, give it more time rather than just eliminating it. I thought it was a good tool.
Nate, do you have a response for that?
No, that's a really interesting question. I know that's something we were going to be looking at. Ann, do you know if we have data already on that? I say already because it's still a fairly new policy. Well,
And
Yeah, I think I got myself unmuted.
yes, you did.
Okay. We don't have the data on it yet, but we are seeing it. I mean, I've been coding these past few days. I've been coding departure reports, and the judges are writing back some cases, but they're writing back to say no, it's not a departure because we waived the custody point. But they never let us know through filing a modified worksheet that they waived the custody point. So we thought it was a departure. Jill might have an opinion about this. Jill?
you know what, let me try promoting Jill and
'Cause I think she looked into what we have to, in our current database, but like I'm saying, it's happening and we don't know about it until we ask for the departure report.
So Jill, do you have any information? I see you're there now.
maybe that's the wrong Jill. There's two Jills out there for some reason.
Oh, there we go.
Katie, I also promoted you, so if do you have any information on that?
I don't think they.
I think
I
so,
would
yeah.
I would have to look at what we've already done.
So, and I would say just from a timing point of view, it's problematic because the policy went into effect, at least what we thought at the time, right? Before Robinette was decided, the policy went into effect on August 1st of 2019, effective for crimes committed on or after that date. So it didn't affect very many crimes in 2019, and we still haven't finished the 2020 data because we've been short-staffed this year. So, and Jill's saying there are very few cases where this has been indicated on the worksheet. So, I mean, and keeping in mind, it's really only, I mean, it's most salient when it causes somebody to cross over the disposition line. And that's certainly true in some cases.
Commissioner Estrada, are you raising your hand at this point?
Yeah, if I can just also point out that because we don't have clear directions on the half point, and judges can choose if they're going to round down or round up, that half a point, which they may have waived, they don't have to mark it as being waived, and we don't have to mark it on the guidelines worksheet. We as probation officers don't have to mark it on the guidelines worksheet because they're just rounding down and it's not technically being waived. So even if we do have that data, it's going to be skewed.
Okay. I think Commissioner Knudsen had his hand up a while ago, so let's go back to Commissioner Knudsen.
Thank you, Madam Chair. I entered this debate coming in as a new member, thinking we were going to solve and provide some clarification for what we do with a half a point. And it has morphed into the elimination of the custody status point in my mind, which I don't think is right and I can't support. If a person is in custody, on probation, they are more culpable. They are more deserving. They are more blameworthy. We haven't gotten their attention. And they are out violating the safety of the public. And I don't know how we can vote publicly to eliminate that custody status point and send that over to the legislature. It's going to be quite the Donnybrook over there if we vote to do that. In Minnesota, it's not like we're incarcerating everybody that comes before us. We're the fourth lowest state per capita for incarceration in the country. We're coming off recently in the last several years of significant drug reform sentencing the Drug Reform Sentencing Act, a significant reductions in sentences in those drug offenses. We've created drug courts in nearly every jurisdiction. And we're looking to bring in anybody and everybody we can to those drug courts to avoid having to send anyone to prison for a drug offense. We do have a lot of ways of punishing people that come before us, but it's not necessarily about punishing, but it's also, it's like I said, it's getting their attention. But all the variety of those different types of sanctions, we need the guidelines. That's what we're here for. We need a set of guidelines. We need some uniformity in the application of some kind of sanction, some kind of punishment, some kind of consequences when a person commits a crime while they're on custody status. So if we eliminate the custody status, that doesn't eliminate the consideration that the courts are going to make in sentencing somebody. It's just going to be such a disparity across the board that we're not going to have any uniformity when the judge does take that into consideration. You know, Chief Axtell, after the shooting in St. Paul, was quoted in the paper saying, you know, it's a result of the crime that they're seeing is a result of the revolving door. And that's what we're dealing with, is the repeat offender that's not being held accountable. And of course, he points his finger at the judiciary, and probably includes policies that are being made. So I guess I'd like to hear what the law enforcement position is on eliminating the custody status, and how law enforcement can help protect the safety of the public upon the elimination of the custody status point.
Could we hear from Commissioner Blakely on that?
That's up to Commissioner Blakey.
Blakey.
And I don't mean that was more of a rhetorical question, but if she's available to comment, that'd be fine. But otherwise, I mean, I'd like to hear what they have to say, probably at the public hearing, of course.
Yeah, for sure. And hopefully we will. All right, I'm seeing the hands I'm seeing up that we haven't heard from are Commissioner Ladd and then Commissioner Schnell.
Thank you, Madam Chair. And I don't mean to jump in front of the law enforcement representative, because I'm the county attorney representative here. I just want to start by saying that, you know, I've actively engaged in listening to my colleagues around the state on this issue because it's important to my colleagues. And I've actively listened and engaged in active listening with all of you at our meetings on this. And I had the opportunity to participate in that subcommittee about all this. You know, one of the things that struck me last meeting with Commissioner Estrada talking about, you know, why do people continue to find themselves on probation when other offenders may or may not? And she, you know, talked a lot about resources, access to programming, and some various types of reasons why offenders find themselves on probation for longer period of time than other similarly situated offenders. And I can say, as a practitioner in the trenches out here in greater Minnesota, in one of the poorest counties in the state, I am acutely aware of the resources or the lack of resources and how that plays into a particular offender's success or not on probation or their supervision, which triggers this custody status designation. But resources or opportunities are not the only factors that affect why someone continues to be on supervision. And there are various other factors, and there's a lot of them, why they continue to be on probation. And this is evident when we're dealing with offenders who are appearing before the courts on a 4th, 5th, or 6th probation violation before a sentence is ever even executed. So The argument about resources and opportunities or other barriers that face offenders on probation are articulated every day in court throughout the state, and that is getting full consideration on any particular case. To Commissioner Middlebrook's point, those are the kinds of things in a particular case that get addressed before the court. Similarly, those are the same arguments that are being made when persons are making motions to the court for departures, which brings up the point Commissioner Larkin brought up last meeting when she asked the question if somebody had a custody status designation and it was used as part of the process for departures. Is that custody status designation an offense characteristic? Is it an offender characteristic, or is it both? I think those are really good questions, but we don't have the answers for those because we've not analyzed that. We don't know how that should factor into this or how that should be viewed. And I think if we're going to move forward from a custody status point system to a custody status designation process of some other format, we should give some weight and bearing to those things, and we just honestly have not done that. Another issue that was discussed at the last meeting that struck me of a point of interest, and I apologize, I wasn't sure if it was Commissioner Moore or Commissioner Knudsen. I couldn't read my handwriting, so I apologize for that, was reviewing how or if we use misdemeanors, gross misdemeanors, as well as the juvenile points in our criminal history score. And I think Nate put that on one of the graphics today about the various things that kind of go in to complicate it. Those are good questions, and I think there should be further review of whether or not that should be part of this. So the reason why I sort of highlight a couple of these things is because these were important things of various aspects of how custody status sort of bleeds into or leaches into other parts of the guidelines that have impact on disposition of cases. But I take myself back and remind myself we're here for a narrow task, which is to how do we handle this half a point regarding custody status, and how do practitioners use it and calculate it in courts in Minnesota. And currently the guidelines are silent on that. So while I feel like our task was narrow in scope at the beginning of this, it really did lend itself to larger discussion and rational questioning of other aspects of our guidelines beyond how to simply calculate this point. As I said, this custody status point or designation, it matters to me as a county attorney. And there's consensus amongst my colleagues that this also matters. In full candor, I will tell you that my colleagues weren't particularly excited about any of the three that we narrowed it down to. A recurring question always comes up is why not take the sum of all points, the felony points, the custody status point, and make the rounding rule the sum total of all points, whatever you call them, and then just round down. And I don't know that I've gotten a clear answer on that, and it seems like that could be a simple solution. But here's where I find myself in the pure sense: if there are two similarly situated offenders that commit the same crime and have the same criminal history score, and the only difference is that one offender is on custody status and the other is not, they should not get the same consequence for crime X, whatever that is. I mean, I know that's very basic, but that's really what we're talking about here. So honestly, of the three options before us, the only option that gives full weight and deference to the prior commission's decision to reduce the weight of custody status from 1 point to half a point, and also to differentiate between those offenders who have done and are doing what we ask them to do and what they're supposed to do when they're being supervised, distinguishing them from those who are not doing what they're supposed to be doing. They should not be treated similar in terms of consequences. And I would just like to also say that I do think that it's problematic that we have a vacancy on the commission right now and a voice. I don't know what that voice would say, but I can't imagine that a victim representative on this commission would be in support of an elimination of the point. And so I think of the three options that are out there, if we're going to move forward with the decision today, the only option that I could support would be the half point grid. I think the other two are just not something that addresses the concerns from my perspective. And I think there's been more questions that have come up than have been answered in this process. And so I think we've got a lot of work in front of us. So thank you, Madam Chair.
Thank you. Commissioner Snell, you were next.
Thank you, Madam Chair. This has been, I think, a really great discussion, and really appreciate the range of perspectives. As I go back to thinking about Judge Larkin's kind of question about the impact on public safety as the number one thing, and I think when I ask myself the question of the extent to which sentence as a crime fighting strategy is effective, which clearly I think that's, as I look at public safety, at least in that narrow definition, and then ask myself the question about incapacitation. Certainly, while it's really look at what are we talking about as we look at the as we increase the sanctioning because of custody status, what the differences in the sanction or sentence length would be. Clearly, I mean, on every single level and individual, from a few months, several months, to perhaps a considerable number of months. The benefit of that incapacitation time, that they're not in the community may have some benefit. But I think as we look at and think about the totality of the state's kind of sentencing scheme, if we think that that sentence length as a mechanism of fighting crime has been effective, we're going to get to a point where the system is simply way too costly for us to be able to maintain. And I would argue that, across the spectrum, and I would say even across sometimes the political spectrum in terms of criminal justice reforms and thinking about the size of the system and the effectiveness of the system and the impact of the system in ways that are beyond even the pure question of the benefit of that incapacitation, that term that people would be incarcerated for whatever incremental term that may be, in terms of its benefit. I think those issues have been called to question, not just by people who may take a more progressive view, but I think even on the other side of this issue. And so when we talk about strategies for addressing crime, which is really the broad question, the thing that we're really, I think, talking around, this sentencing kind of scheme doesn't seem to have, it hasn't been effective. Frankly, in our state where we have that relatively low rate of incarceration, and frankly, it hasn't been in the states across our nation where it has been, sentencing has been at the highest ends. That hasn't produced necessarily significant differences in public safety outcomes. And in fact, if you look at what's happening around the uptick that we've seen over the last several years, as Judge Knudsen raised, I think that is not a unique, that's not unique to Minnesota. And so just to make sure that we're thinking about this in the broadest sense possible around the fact that that sentencing as a crime fighting or crime reduction strategy in and of itself is not a sustainable strategy. The second thing I would just say is that the research has been pretty significant. And I as a person responsible for them, it's not always easy to say, but incarceration in itself has been clearly shown to have having a criminogenic effect. In other words, that sometimes people who have been engaged in the system more and more end up more and more engaged in the system. Now, I'm not suggesting for a minute that we don't hold people accountable. In fact, I think it is critical that we hold people accountable. But I think as we look at the question of effectiveness and the question of incapacitation as a crime reduction strategy, I think we have to be honest about the fact that it is not a sustainable strategy. And that has been proven in our country, where, you know, we have people incarcerated at the highest of anywhere in the world. And I think that's there's a lesson here that as we look at what's happening and we face profound challenges, I acknowledge that. This is not about you know, this is not a law enforcement problem. This is not a court problem. This is not a corrections problem. This is a challenge that we face that I think we have to answer. But if we think that the answer is going to be found in the custody status point, then I fear that the outcome of our effective crime reduction strategies or our response to upticks is not grounded in really good policy, but grounded in a level of fear, a response that has not been shown to be effective over the long haul. And I think our responsibility is to at least consider that factor as well. The final thing I would just say is that you know, I would be interested in hearing if the concern is you know, that custody status has been a part of our history, but there's been little recognition about the fact that, you know, for the people that are on the line, right, that go on the other side of the line because of custody status, and looking at the types of offenses that are most, you know, impacted by custody status. You know, I think there is a question about, you know, the effectiveness of that response. The fact is that they do have they would have the point for their current offense, and at least in the felony cases. I struggle to see going forward how it is that ultimately we would, you know, it would significantly benefit public safety to maintain that custody status point. And I would be interested in knowing. And so as you look at people who have higher levels of criminal history, significantly higher levels in some case, I would be interested in hearing from others about the whole question of the about looking at the exemption option of making this a using the factors that would ultimately allow the application of the custody status point, because then perhaps it is more in line. It has some disadvantages, but is perhaps more in line with the concerns I'm hearing about the repeat, the highest levels of repeat offenders.
Commissioner Larkin. And then Commissioner Middlebrook.
Thank you. And thank you for those comments, Commissioner Schnell. I too am influenced by those heat maps showing that, okay, the people with the custody status point are sort of congregated in the middle low-level offenses. But my concern is we're talking about eliminating the custody status point for everyone, not just those low-level offenders. There are other options we could consider in terms of, you know, well, let's only use a custody status point for more serious offenders, more serious offenses. We had one such proposal on the table, but it was not well received. It doesn't mean we couldn't look at doing other things. And this is one thing that I just keep coming back to. I feel like we were tasked with this small task of figuring out what to do with a half point. Do we round or not? And now it's morphed into, do we get rid of custody status for everyone? And there's a lot of ground in between. And one of the things we could look at more closely instead of eliminating the custody point for all offenders, is just eliminating it for low-level offenders or low-level offenses and figuring out what the proper balance is there. The second point I'd like to make has to do with Justice Moore's comment about the waiver provision. You know, it's interesting to me that, you know, the way the guidelines are now, consistent with common law, it's presumed you're more blameworthy if you commit offense while in custody status, but the judge has the ability to look beyond that if your circumstances show no threat to public safety. So we have that there. We're talking about a complete philosophical switch where we would say either you're not more blameworthy, no one gets a custody point, or if you're more blameworthy, somebody has to prove it as a substantial and compelling circumstances to get to a departure to get some more time. And that has to do with this third option, which no one's really spoken to, and I'd like to at this point. I don't support the idea of using custody status as an upward departure factor for several reasons. You know, the things we do here have impacts not only in terms of public safety, but they impact the practice of law and what's happening in the courts. And we have to be respectful of what case law says and what the rules say about how departures work. And, you know, I point out, even the guidelines say, you know, you don't depart unless there are substantial and compelling circumstances to support a departure. And that the factors listed as examples of departure factors are intended to describe specific situations involving a small number of cases. The Commission rejects factors that are general in nature and that could apply to large numbers of cases, such as intoxication at the time of the offense. I look at custody status at the time of the offense. That applies to a large amount of cases. That's not a unique and compelling circumstance. So it seems odd first to say we're going to treat that as an upward departure factor and say that it's a unique and compelling circumstance when it's a circumstance that applies probably to half the cases out there. The other thing that concerns me about treating it as a departure, aside from the jury trial issue, although I'm not sure that's really an issue, is that if you establish a substantial and compelling circumstances justifying a departure, the judge has the ability to sentence up to the statutory max with certain rules about limitations to double upwards, etc. We're throwing a new wrench in it. We're saying, well, here's this departure factor, and if this is established, you don't look at the statutory max, you just go up one box. So we're giving it a different treatment. And to me, that would lend itself to more confusion in arguments about uniformity in sentencing than to simply say, well, we're going to have half-point boxes. The notion that, well, people are going to be confused because, you know, you round down for felonies, juvenile is only 1 point based on 2 offenses, and gross misdemeanor, misdemeanor, 4 points, 4 partial points, you only get 1 full point. Those are easy. Anybody that practices understands those rules. The notion that, well, there's going to be this half point for custody, that's been there for 2 years. We're not creating that confusion. We've been living with that for 3 years now. But what we're talking about doing in terms of departure are significant changes that are inconsistent with departure law. Again, as Commissioner Ladd pointed out, if you're going to base a departure on a circumstance related to the offender, it's only supposed to get you a dispositional departure and not a duration departure. And then when you look at the reasons for departure, they're generally having to do with, if we're talking about durational departure, what makes this particular crime worse? And we look at, you know, how was the crime committed? How was the victim treated? Were other people put at risk? We're really focusing on the crime itself. Well, now we're saying, okay, set the crime itself aside. Just based on the fact somebody was on probation, that's a departure ground. I don't see how that could be anything other than a dispositional departure ground given our case law. So All I'm trying to do here is point out that these pithy ideas we have about, well, let's just make custody status a departure ground. It's not that simple, because it needs to work in the context of all the case law that governs departures. And it is very inconsistent with that case law, which is why I don't support the third option. You know, and one final point. As long as I've been on this commission, I keep hearing statements that lead me to believe that what people are really unhappy with is the fact that we have determinate sentencing. People are constantly saying, well, we want to take a closer look at the individual. We want to weigh this. We want to see what his or her needs are. We can't have a one size fits all, but one size fits all is the guidelines. What we're supposed to be doing here is treating similarly situated people similarly. So if you commit a theft over $5,000 and you're not on probation, you're not similarly situated to somebody who commits theft over $5,000 and you are on probation. You get treated differently. But now you're talking about doing away with that and saying, well, let's leave it up to the judge to decide. That is inconsistent with the guidelines as a whole. And for those reasons, the only option I can support of the three that are on the table is the first option, which calls for a half-point grid. Even though it is more visually complicated to look at, I don't think it's complicated to use at all. You just find the number and go down the grid and there's your sentence. It's quite simple. And unfortunately, if it doesn't list sample offenses on the side, I'm sure capable county attorneys would be able to open the grid and use examples without having them printed on the side of the grid. And I mean, if the balance is, well, we can have this grid with half points, that's going to result in proportionate sentences that treat everybody the same and impose the custody consequence across the board similarly. I think that's a better outcome than saying, well, we're going to look at doing these other things because we're going to lose the ability to have sample offenses on the side of the grids.
Commissioner Middlebrook.
Thank you, Madam Chair. I want to just circle back to Commissioner Moore's question about on the waivers and from the public defender side of it. I will say that for the appellate office, we have not seen any of these waiver cases come through at all. So, and that may mean that if they're getting the waivers, they're not contacting the appellate office to appeal, but I can probably guarantee that if they didn't get the waiver, they would contact us to appeal. And we haven't seen any, but again, it's also relatively new given the time frame here. So I just wanted to circle back and answer that question. Another point that that came up is about, you know, Commissioner Larkin, and you focused on that the custody status has always been part of the criminal history score going back to common law. And, you know, obviously we're in a different era now, but how the guidelines, from my understanding, how they came into using the custody status was from the parole board. And so you're talking about back when the parole board was deciding on when someone was going to be released and their conditions on release. One of the things that they were looking at was their they looked at custody status as one of the risk factors. And obviously we have come so far in advances now on the risk level tools that really doesn't mean anything anymore. And we need to look at what our risk level assessment tools are now. I wanted to address a little bit of what came up on the aggravated departures. I do see that is an option here with eliminating the custody status as part of criminal history. And, you know, we're the Guidelines Commission. We can write in what we feel is an aggravating factor that can be taken into account in sentencing. And we can also change that to be, and I think, you know, actually the proposal is that it's related to both the offender related factor and the offense related factor. because sometimes it goes to culpability. Sometimes it goes to the amenability of probation for that particular individual. And we can write that in. We can put a comment in to address that. I don't really see any problem with that. And the idea that we have to follow those dispositional and durational departure factors, we don't have to do that. We can make this exception for this particular factor, and it can be applied where it should be applied and where it's appropriate for that particular individual case. The other point that came up was on the limit on it. The reason that the limit is on it is that it reflects what the custody status point does right now. It moves one cell over to the right or two cells on the sex offender grid if both the current and the past offense were on that grid. So that's the reason for the limitation. And again, as the commission, we can write that into the guidelines that will be straightforward and people can follow that. One of the concerns, I'll switch back over to the half point grid. I've talked to a lot of colleagues and about this grid, and I will say universally, the comments that I get back is that it is confusing. It's also going to be really difficult for one of the comments was it's going to be really difficult to explain this to the clients. Right now we have a grid. We can show them what the examples are. We can show them it's a very easy grid for them to look at. Obviously, we have to do a lot of explaining, but just like with the prosecutors and the victims or probation and the victims, showing them that particular, the grids we have now are way simpler. This one is very, very difficult with all of those cell blocks in there. Also, I think that, flipping back into the guidelines themselves to show which, as examples, it's not as easy as you say that is when you're in court or you're in talking with, whether it's victims or defendants. It's still very, very, you're not always carrying your guidelines, the whole book with you, or the whole rules book with. So I think that those are a couple of things that I heard back about that grid. And I also think that what it does is it doesn't really reflect what happened with the prior commission, because as we talked about multiple times, that half point was really a compromise. And I think now this opened it up to looking at some other options that make more sense, that are, can take into account public safety and all of those concerns that have been brought up. So those are a few things that I just wanted to bring up in response to other commissioners.
Okay, Commissioner Estrada has her hand up. Then I want to make a comment, and then I think we'll take a break, and then we'll come back and continue the discussion. So Commissioner Estrada.
Thank you, Madam Chair. I would agree with Commissioner Middlebrook in terms of feedback that I've received regarding the half point, it complicating the guidelines, it having a larger area, room for error, the inconsistency of rounding down in some sections and not rounding at all in other sections. There's so many different ways that it can play out. If somebody has a half point in the felony and somebody, just goes and says, oh, this person has 3.5 points, and then tries to put that person there, but it's in the felony section, it can be people who are adding them all together and then gets a half points. There's a margin of error there that I think is larger than people are giving credit for. I would not be in favor of the half points. I do want to kind of again reiterate, I don't have a problem with determinate sentences. What I have a problem with is when we have data that says that a custody status is predictive of recidivism, but it's an additional one out of 100. That's 99 people that it doesn't really make a difference for out of 100. We are making decisions based on 1 out of 100, which obviously on a grander scale, it's more, but it's also more people who it doesn't make a difference for. When I hear things like it's to get their attention, we should be using, you know, these prison commits or these lines that are going to move a person to prison for the people who need it, not because we're mad at them. And if you look at the graphs again, they're the low level offenses that we're looking at. They're the people who are going to be presumptive sentences anyway, presumptive stay sentence anyways. When we're working with clients who are drug addicts, it's not uncommon for somebody to relapse and pick up a new drug offense. And yes, drug courts, I worked in drug court for 6 years. I helped develop the Hennepin County Drug Court. I was one of the POs who helped develop the whole curriculum for that. We have a lot more clients on supervision across the state that are not in drug courts or that do not go into drug courts, or there's not the capacity to go into drug courts. And that's the capacity of judges, attorneys, probation officers, etc. So I want to point that out, and I'm consistently going to go back to what is our data telling us? What does it say? Let's stick to the facts here, and we have to put our moral judgment aside.
So the last comment that I want to make is, you know, what I think about a lot, I mean, I've spent my career in policymaking. Everybody knows that. I'm not the frontline attorney, right? I'm the policymaker here. But what concerns me is when we have policies that look to be uniform on their face, but are not uniform in application. And I think that as a commission, we have to be especially attuned to the situations where that occurs, because, you know, those are the easy policies to justify because they look good when they look like they're applying to everybody. But it's our job to look at whether they really are and how they're applying. And if they're not applying equally, if they're not being applied uniformly, then we have to question whether that's good policy. And IC custody status is one of those policies that is not being applied uniformly. I talked about this a little bit at our last meeting, but what I mean by this is that what the custody status consequence does right now is it moves you 1 cell or 2 cells to the right of where the presumptive sentence normally would have been. And as we can see on the sort of heat maps, most of those people are in the presumptive stay zone of the grid. So the actual effect on their sentence is really nothing. They're getting, you know, maybe if they have a stay of execution, a longer sentence is being pronounced, but they're mostly not going to serve that because they're not, that sentence is not being executed. For the people who receive a stay of imposition, nothing different is being pronounced. So we're not actually imposing more punishment on these people that we've heard some folks today saying are more blameworthy. So the people that are really getting hammered are the ones that are on the dispositional line. And when they move 1 cell to the right, not only are they getting prison now instead of probation, which the guidelines call for if you have a higher criminal history score, but they're also getting an increased prison sentence. So I think, you know, that it's falling disproportionately on people who are in that zone. The effect is much harsher for those individuals. For the rest of the folks who are in the stayed zone, it's almost non-existent unless they have a violation and get revoked. So I just don't see that this is a policy that is actually being applied uniformly in application. It's not actually working uniformly. Commissioner
Can I
Larkin,
ask a
a
question?
Sure.
Yeah, I just want to question that. I don't understand what you said, because everyone in that example you gave is getting treated as he or she should be treated under the guidelines. And to say, well, if you're at the lower, if you're towards the left, it's not really impacting you because you're not getting sent to prison. But if you're on the line, it does impact you because you're moving over the line. Well, a person who's on the line is not similarly situated to a person who's in the first or second box. So I just don't understand how this is impacting people disproportionately. I mean, you could say, well, the effect is more harsh for the person that's on the line, but that's as a result of that person having a greater criminal history score than somebody who's nowhere near the line because they only have 1 or 2 priors. So it's not as if similarly situated people are having a different impact as a result of the custody status. It's just working as it should work, which is as you accumulate a criminal history, you move across the board, and at some point you get to the line and you cross over it. And again, what about the people who commit the serious crimes? What about the people who aren't way down at the bottom? What about the people that, you know, are on probation with a downward departure for, you know, second degree assault with a weapon or illegal firearm possession, and they commit a new offense? Why is that person not more blameworthy? And what about the sex offenders? Right now, certain sex offenders get 2 custody points for certain offenses. And we're talking about just eliminating that. What are we doing to ensure?
And we also see that most of them don't get custody status. We're only seeing the people who fail to register getting the custody status. So, you know, I think it's, you know, you can throw out the more extreme examples, but the reality is that we're talking a lot, mostly about people moving around within the stayed zone where they have no impact on their sentence. So what is custody status doing for us there? Nothing. Or people who are on that dispositional line who are getting pushed across it. And only in those cases really is custody status actually functioning and providing more of an impact. That's just my view.
Well, then I think what you're saying, so then why do we need to change anything? If it's not impacting people and it's not really harming people, why are we changing it? What are we
it's impacting some people more than others. I mean, honestly, it's impacting some people harshly and some people not at all. And that is not uniform. That's the issue that's what I'm saying.
But that's because those people are not similarly situated.
And
I mean, anybody who's on the line and gets an offense at the custody point goes over the line. They're similarly situated. I don't think you can make this about unequal treatment of people or disparate treatment of people.
I disagree. Commissioner Estrada.
I struggle with that argument, Commissioner Larkin, because if I remember correctly, your argument against adding them all together and then rounding was exactly the argument that the chair just made. It's applied the same, but it's done differently, right? Like the impact is different, was your argument. So if you had somebody
It wasn't my argument. My argument was, if we're going to have a custody status, it should apply to everybody. And the way we have it now, where it's at a point,
I'm talking about the very first
if
one.
you have a criminal history score that ends in a half point.
No, I'm talking about the very first time that this came to our attention by the staff, and there was a proposal by the staff that came to us and said, we add them all together and then we round. And from that, I think Professor Fraser also came and talked to us. From that, what we saw was it was being applied the same across the board, right? Add it and then go up or down. And what you pointed out was some people could end up at a 3, some people could end up at a 2, depending on if they're felony or whatever. I mean, the scores are a little different, but some people would have a higher sentence, some people would have a lower sentence if we're adding them all and then rounding, because in the felony section, somebody could have a 1.5 and somebody else can have, 2 drug offenses, which is just 0.5 and things of that sort. I mean, we can look at the minutes, but I believe
why are we looking at minutes? Why is this turning into a personal attack?
Nate, maybe you can shed on some light as to why that proposal was shut down. But I believe some of the argument that you made, as well as Professor Fraser, was that the result of it was some people were getting higher sentences, some people were getting lower sentences, even though it was being applied similarly.
Well, I would just like the record to reflect what my opposition was, which Professor Fraser agreed with, as opposed to your recollection of my opposition. The problem was that by adding a half custody point, if it didn't bump you up to a whole number, you weren't going to get the custody consequence. And that seemed unfair, that somebody who would have a criminal history score of 4 and then got a half custody point, there wouldn't be any additional consequence for that person because be it a 4.5 and it's not on the grid, you'd round it down. But if somebody had a 3.5 criminal history score and got the half custody point, they go up to a 4 and get a consequence as a result of the custody point. And my concern, consistent with the guidelines desire to have consistent consequences, was that if we're going to impose an additional consequence as a result of custody status, it should apply to everybody who has custody status. And it shouldn't depend on what your criminal history as calculated on priors happens to be. And so that was the concern there, to make it an even playing field so that anyone who was on custody status would get the consequence. Because I think prosecutors wrote to Nate and said, this is ridiculous because the person's a 3, we give them a half point, so really this custody status is meaningless. There's no consequence that comes from it. And that's absolutely true. So that's what we're trying to avoid.
All right, well, we are now at 3:04, so we'll call that 3:05. And I think it's time to take a break. Thanks everyone for the discussion. We'll come back at 3:15. And then when we do come back, if there is any member of the commission who is prepared to make a motion on any of the proposals that we have before us, that would be an appropriate time to do that. We can continue the discussion, but I will see you all back at 3:15. Thank you. Okay, the time is 3:15. Are we live, Nate?
Yes, we are.
Okay, so I'll ask everyone to start coming back if you're not already there. All right, so we've had a fairly extensive discussion this morning about the sort of the underlying philosophies that relate to the 3 proposals that we have under consideration for today. Now we're getting to the point where it would be appropriate, if there's a member of the commission who wants to bring a motion forward, to do that. Before we do that, I would like to ask Nate to just remind us how to frame an appropriate motion, given the fact that we are not making a final decision today. Nate.
Thanks, Madam Chair. So this would be well, I guess it's been framed different ways, but essentially what's happening is you'd be preliminarily adopting a change to the sentencing guidelines subject to a public hearing. So you could say, you know, I'd like to preliminarily adopt proposal X subject to a December public hearing. And then the next step is that we would put a notice in the state register for that public hearing. But it's also been said advance to public hearing. I'd like to advance proposal X to public hearing. That's, I think, also adequate. And understand that all this would be subject to the public hearing, final adoption in January, submission to the legislature by January 15th, and then it would take effect on August 1st, 2022.
Commissioner Larkin.
Thank you. I move that we advance proposal number 1, displaying half points on grids, to public hearing for further consideration by the commission. I do that not because I think it's the best solution, but I think it's the best solution among the 3 we have. I wish we had more time to consider other solutions, but I think as staff has pointed out, the half point on grids allows us to keep public safety outcomes more similar to the status quo. It reduces prison beds. It doesn't require, significant changes to the guidelines other than making the chart have more numbers, which I refuse to concede makes it more complicated in application. The practitioners are completely capable of understanding a chart with more numbers in it. And just for the reasons that the comparison chart gives, I think it is the best way to address the problem that brought us here today without compromising public safety.
All right, so Commissioner Larkin has made a motion. Do we have a second?
Commissioner Ladd, I'll second that.
Commissioner Ladd seconds. Any discussion on the motion? Commissioner Moore.
Thank you, Madam Chair. Well, I speak in favor of the motion, not because it's a perfect solution by any means. I share the comments of Commissioner Ladd. I wish we had more data. I wish we had more information regarding how much the waiver of the custody status is being utilized. I get the sense that the custody status point is being asked to do a lot of work here regarding really some very profound and greater policy discussions here beyond just this particular problem that are important discussions and deserve continued debate. But we have to do something given the confusion that's been created by this half point issue. I had hoped we could find a middle ground here, and I was hoping that maybe the third option might be that middle ground, but I was convinced after reviewing Nate's materials and just hearing the discussion here, I agree that the impact on the district courts is a concern. The district courts right now are dealing with serious backlogs in the area of felony criminal cases. I don't really know, frankly, how much this would be utilized as an aggravating factor. And so I am concerned about the comment that Nate made about there being not uniformity and there could be disparity as to how option 3 would be utilized depending on which jurisdiction you're in, given the attitudes of the prosecutors and the judges and frankly the backlog or lack thereof. And so I don't think that necessarily gets to the uniformity of similarly situated people being treated in a similar way. I think there's a lot more that could be said about the overall issue, but given that we have to make a decision here, and given the concerns relating to public safety, and given, frankly, the question in my mind about, what the impact of this really would be, given the types of offenders that it would affect, I think it's the most reasonable option on the table currently.
Other comments?
Madam Chair.
Commissioner Schnell?
I just, I would take a little bit different view. I get concerned when we say that that at some level, either the half point, which I think as it was characterized is more similar to the status quo than the other alternatives, that somehow that weighs more equivalently with public safety. And I really think that level of oversimplification, I think, does become a challenge for us. And I get that there's a lot of complexity, but I can't. I also cannot disconnect the realities around the fact that this is going to have broad implications, and when I think it really is a public safety benefit to a very small number, at least in looking at some of that the research data that we have in front of us. And I think that over application does create a challenge, and given the broader data around criminogenic factors, I think it's hard to to support that. So I would just speak in opposition.
Any other comments? Commissioner Knudsen.
Well, I too speak in favor of this proposal for the reasons I gave before. I'm not convinced by the research that's supposedly before us that we have very little time to digest, but that's talking about mainly the harsh prison sanctions overall. Much of it is, and the criminal history score in itself, and not the custody status point. I wish and I believe that there is a way to resolve this in a manner that accomplishes the keeping of that consequence and having that over people's heads that you could pick up a point simply for committing another offense while you're in custody. But and I think that solution would be to craft a reasonable proposal to eliminate the half points and the accumulation of half points, so that we would only be dealing with a full point at any given time, and it would be mainly on the more serious felony offenses. I think that would satisfy the concern about having that as having the custody status point out there, and offenders knowing about that, but also eliminating that those hot spots on the lower end of the grid. But we don't have anything like that before us. I wish again we had a little more time to flesh a lot of this out. But I think option one, with having half points, having a grid that it's very similar to what we have now, is the best option to clarify this for the district courts that are really straining and trying to figure out what to do with this at this point.
All right, any other comments? All right, I'll make one comment that I think the only thing I hadn't said today that I wanted to say was the concern I have with this particular grid is the fact that we would then have like different rounding rules for different elements of the criminal history score. That we have, felonies being rounded, we have the misdemeanors and gross misdemeanors being subject to the, quarter-ish point concept. And then for custody status, we wouldn't round it all. And I just don't think I think that sort of grates for me as being a very inconsistent treatment of the different elements of criminal history. And for that reason, I just don't think that the underlying policy works from my perspective. In addition to the other issues that were raised in the staff by people today about just the grid becoming more complicated. That's the only other comment I wanted to put out there. Any other comments from anyone else? All right, well then, hearing none, I guess, Nate, please go ahead and call the vote.
Excuse me, to the Larkin motion to provisionally adopt and advance to public hearing Proposal 1, Estrada.
No.
Estrada, no. Blakey.
No.
Blakey, no. Hansi.
No.
Hansi, no. Knudsen.
Yes.
Knudsen, yes. Ladd.
Yes.
Ladd, yes. Larkin.
Yes.
Larkin, yes. Middlebrook.
No.
Middlebrook, no. Moore.
Yes.
Moore, yes. Schnell.
No.
Schnell, no. Chair Mitchell.
No.
Chair Mitchell, no. Madam Chair, there are 4 votes in favor, 6 votes opposed.
And with that, the motion fails. Does any other member of the commission wish to bring a motion today? Commissioner Estrada.
I would like to move forward the motion to preliminary adopt subject to public hearing. Motion, proposal number 2 to repeal custody status policy without replacement for the reasons that we have discussed. I believe that it aligns with evidence-based practices and reform that is happening nationwide regarding sentencing and probation. I would also focus on, or I'd also like to point out that 2 years ago, I believe it is, we, the commission changed some of the guidelines to, for sentencing for repeat violent offenders. So I think that that is something that is in place that safeguards some of our violent offenses where there's concern about additional punishment. And then I'd also re-emphasize the data sheets and the data that was provided by staff today with the heat charts in regards to the sex offender charts and how very few people have custody status points.
All right, so we have a motion. Do we have a second?
I'll second Middlebrook.
Commissioner Middlebrook seconds. Any discussion on the motion? Sounds like the commission is discussioned out. So I think with that, we can go ahead and move to a vote.
To the Estrada motion to provisionally adopt and advance to public hearing proposal 2. Estrada?
Yes.
Estrada, yes. Blakey? Blakey?
Yes.
Blakey, yes. Hansi?
Yes.
Hansi, yes. Knudsen?
No.
Knudsen, no. Ladd?
No.
Ladd, no. Larkin?
No.
Larkin, no. Middlebrook?
Yes.
Middlebrook, yes. Moore?
No.
Moore, no. Schnell?
Yes.
Schnell, yes. Chair Mitchell?
Yes.
Chair Mitchell, yes. Madam Chair, there are 6 votes in favor, 4 votes opposed.
And with that, the motion is approved. So option 2 will move forward to a public hearing. And Nate, that is the next date, our next regularly scheduled date. Am I correct? Can you inform us of those details?
That's correct, Madam Chair. So, and I could discuss that in my executive director's
Oh,
report.
sure. Okay. That's
Kind of
fine. We
really
can
all
get
it's
done.
talking.
We can, okay. That sounds great. That sounds great. All right. So, oh shoot, now my computer doesn't want to let me see the agenda. Okay. So that ends item 5, which was custody status. The next item on our agenda is preview 2022 report to the legislature. Nate, I'll turn it over to you for that one.
Thanks, Madam Chair. And this is also all related to the December 16th meeting. So we are going to have, our next meeting is on December 16th. The way I envision it, subject to your approval, Madam Chair, is that we would have a public hearing at 1 o'clock. People could comment on the proposal, and then we would move on to a meeting. Now, I'm hoping we will have time for a meeting because we really do need to meet. We need to, I mean, I guess, 9 times out of 10, we don't get much comment at all. And then that 1 time out of 10, we get, hours of comment. So this may be that 1 time, I don't know, but we do have to, like basically the one thing I have to do each year is I have to present to the legislature a report before before January 15th of each year. So we would typically be presenting to you the 2020 data at this meeting. We didn't have the 2020 data ready yet because we were short-staffed. So what's going to happen is we're going to be presenting. I'm envisioning the report to the legislature being a little bit different this year, and that's mainly because 2020 was a very odd year, as I don't think anybody needs explaining, and I don't know that there are a whole lot of conclusions we can draw about trends or that sort of thing that might have happened in 2020. I'd like to focus the data portion of the report to the legislature basically on two things. One is, how was 2020 different from a typical year? And then two, what, if anything, what are the early returns? What are the early indications about the impact of the commission's 5-year probation cap limit, which were in effect in 2020? So we will. That's really where I wanted to go on the data report, but we will need to work hard to get that report to the legislature in shape. Essentially, what will happen is you'll look at it for the first time at that meeting. You'll have a chance to give me your input, and then we will meet one more time. But that one more time will be really, really close to January 15th. I think it might be January 4th. So if there's any major movement, editorial movement to go on the report to the legislature, I would ask for that. You to come prepared in December, please, with the hard work of doing that. I have no problem with editorial movement from the commission, but really would like to get that in December rather than January. We might be doing an all-nighter if there are a lot of changes to be made in January. So that's,
So in other
that's
words,
essentially.
you're asking us to do our homework in December. In other
Yes,
words,
please.
come
Yes,
prepared,
please.
read ahead, read the materials ahead,
Yeah.
have done your
Unless,
homework and be ready.
unless you're fine, staff will draft something. If you're fine with that, that's fine. But if you do have some changes you'd like to make, please, yeah, please come prepared to do those. So that's all I had on that item, Madam Chair.
All right. That sounds good. And is that the end of that piece for you? Or do you
It
have
is the end.
anything else?
I
Okay.
think is the next item the executive director's report.
It is. It looks like Commissioner Larkin has a question or comment though. Hang on, go ahead.
Oh, it just as part of the executive director's report, could you update us regarding when we expect to have the empty seat filled, which is supposed to be occupied by a victim of a felony offense?
Thank you, Madam Chair, and thank you, Judge Larkin. Yes, that was pretty much all. The only other thing left I had to say was that. So I was in communication with the governor's office on the day of our last meeting, and they told me that they had actually interviewed a promising candidate that day, but hadn't made any final decisions. But then not much happened in the intervening 3 weeks. I contacted them again, and they said they basically gave me a timeline. And I reminded them each time that we had a meeting today, and the timeline that they gave me was, they're moving through the process, and in the coming weeks was the timeline that they gave me. So it wasn't really it wasn't optimistic that it would be done in time for November 4th, and it wasn't. But I remain optimistic that it will be in time for the December 17th public hearing. December 16th public hearing and meeting.
Commissioner Larkin?
And I assume the December 16th public hearing will allow the public to participate remotely?
Yes. So my plan was to just use G3, which is the room that the chair is in right now. For the benefit of the public, I had a positive COVID test in my household, so I was unable. I figured it wasn't prudent to go to G3, but we should have an opportunity for members of the public to participate either remotely or in G3 at their option. G3, I don't know if some of you haven't been there, but it's got a fairly decent amount of public seating, and I anticipate that it would be big enough for to accommodate the members of the public who would wish to present in person, and then we would also have the remote people as well.
So we'll be doing that, the dual notice again about a hybrid public hearing and a hybrid meeting, correct?
Right. We're planning on staying on the hybrid course through January, and then we lose the room because the legislative session kicks off in February. So we won't have access to the Senate's hearing room anymore. I'm being told that the G3 has a 121 capacity person limit, so that should be plenty big, I think. Yeah, so we haven't quite figured out what's happening in February, but through January, we think we'll continue on with the hybrid approach in G3.
Um, so anything else for your,
No,
you
that
know, one
concludes
thing
my
I wanted to ask you about, one thing I just wanted to clarify on the gubernatorial appointment. I mean, we faced this when our police officer representative stepped down as well. I mean, it took many months for the governor to replace that position as well. And I seem to recall you being told that there was sort of a certain cycle that the governor's office works on for these appointments at that time. So I don't know if that's affecting the appointment as well, but
Well, and not to compare administrations, but it is my impression that the Walz administration is much more efficient at making appointments. And I recognize this does not seem like a terribly rapid timeline, but it is the governor who has to make these appointments, and he's got other things to do. But they are more efficient than the Dayton administration was. We had the vice chair's predecessor. Her seat was vacant for I want to say more than a year or close to a year before that seat was filled. So.
right. All right. If there's nothing else for the executive director's reports, then I think we're on to the public inputs portion.
Gonna pull up my script, Madam Chair. Members of the public listening remotely, in a moment, your microphones will be unmuted. If you do not wish to make a comment, please remute your mic to reduce feedback. If you wish to make a comment, please state your name and the chair will call on you. I am now unmuting the microphones.
Matt Majovsky, Dakota County.
All right, Mr. Majovsky, please go ahead.
Thank you, Madam Chair, Commission members.
All right. You're welcome. Bye.
Hi, Linda. Matt Majovsky, Dakota County Community Corrections. I'm speaking, for myself as not as a representative of our probation department in Dakota County. I wish I could have been at the last meeting. I saw the minutes and the agenda, and I know it was quite an arduous meeting, a lot of discussion, and this one has been, of course, a lot of good discussion as well on the custody status issue. I appreciate the three proposals, and I was leaning more towards proposal 3, which was not brought forward in the vote. So I had all this kind of rationale for supporting that, and I'm saving that for now. I may say something at the public hearing in December. I may not, but I just wanted to express the appreciation, and I know how difficult and complicated it has been going through all of this process. I've always enjoyed the sentencing guidelines because of, sometimes how complicated it can be, and I like that sort of thing, but I know how difficult it can be as well. So I just wanted to express my support and gratitude for all you've done, and look forward to more to come. Thank you.
Thank you. Appreciate your always coming to meetings and telling us what you're thinking. Is there anyone else online who wishes to speak? I think everybody has muted their microphones, but I just want to make sure. All right, and I can confirm that there's no members of the public who are present in room G3. So there's nobody here who's indicating a desire to speak today. So given that, I think we have reached the end of our agenda for today. I actually want to echo what Mr. Majowski just said. I do appreciate the discussion today. I appreciate, you know, everybody had really principled views. Everybody really talked about, you know, what is the purpose both of custody status and of the guidelines in general. I think it's important to have those discussions. I really value being part of a group that's willing to have those discussions. I just really want to thank you for that today. And I hope that we continue to do that as we move forward and look at these other issues. We will have the public hearing in December, so we will get to get a chance to hear reactions to the particular policy that's been put forward, and then we will take that up for consideration again in January. Today, I believe our business is finished, though. And so with that, unless there's any objection, then I will call an end to the meeting. The meeting is adjourned. Thank you.
Everyone.
Thank you.